So welcome to everybody. This is one of our EJIL live presentations, and I have with me Lorna McGregor, who's a reader in law at Essex Law School and director of the Human Rights Centre at the University of Essex. And she will have published in volume 26, number 3, an article with a pretty busy name, Alternative Dispute Resolution and Human Rights, Developing a Rights-Based Approach Through the ECHR. So maybe just to get the discussion going, usually when we think human rights, we always think judicial review, constitutional courts, the European Court on Human Rights, the European Court of Justice, and it doesn't readily come to our mind alternative dispute resolution. So maybe just introduce your theme.
Well, I came about this article in two ways. One as a practitioner. Before I became an academic 5 years ago, I was the International Legal Advisor for Redress, which is an organisation that works on seeking reparation for torture survivors. So within that role, I did a range of things, but a lot of litigation. And as part of that, alternative dispute resolution came up for me twice. One, negotiating a friendly settlement in the Inter-American Commission on Human Rights. And second, when I was trying to enforce the decisions of the Ugandan Human Rights Commission's internal tribunal in the High Court in Uganda. So those were the first times I started to think about alternative dispute resolution and what it meant for human rights. I also worked a lot with the UN Basic Principles on the right to a remedy and reparation for serious violations of human rights and humanitarian law. And there they talk about non-judicial processes, but don't really explain how they comply with the right to a remedy. So I was thinking about it as a practitioner. Then when I became an academic, I was observing that alternative dispute resolution is used a lot in a number of jurisdictions, including my own, and is increasingly promoted at the international and national level. And we see this vast literature on alternative dispute resolution, but international human rights law has had very little to say about ADR. And that's true both in the jurisprudence and in scholarship, but it's not that human rights disputes are actually left out of the equation.
So I could imagine that human rights would have one of two things to say, but not one or the other, but there could be a human rights dimension. For example, now the practice in the United States of many companies, when you buy their product, they say you're obligated with any dispute to go to alternative dispute resolution. And you know, one of those things we blithely say, I accept when we buy something online, and then we discover that we agree to shut ourselves out of the courts. So there's a human rights dimension to that, which is also brought up in your piece. And then there's actually resolving human rights disputes through alternative dispute resolution. So maybe talk a little bit about the first, and then we can go into the second.
The first one is, I think, really fascinating. And I think in a number of European countries, this type of mandatory ADR is not accepted. And there's a lot of discussion around this idea of mandatory arbitration, often in employment, or mandatory agreement-based, like mediation or conciliation. And so there we're thinking about consent and the extent to which we can actually see that the individual has consented to alternative dispute resolution, or ADR. And there's actually a case pending at the moment that I reference in the paper before the European Court of Human Rights, which is the Pechstein case against Switzerland, where an international figure skater, I think, had a clause in order to participate in the World Championship on skating. She had a clause in her contract that she had to go to mandatory arbitration. And so the question there is, have these individuals waived their right to access to a court or not? And in the Pechstein case in the Munich court, they found that there wasn't a valid arbitration agreement. And in the European court's jurisprudence, we see that you can waive access to a court. And access to a court's not absolute, but it has to be unequivocal. And so we'll wait to see what the European court says, as you say, not in a human rights case, but in an access to a court case to see whether it finds that this type of clause constitutes a waiver or not. I think it's a very interesting and difficult question where you haven't been able to fully participate. You have to either, you can skate or you can't skate unless you sign this arbitration clause. There's some scholars who argue that the employment contracts are slightly different, where in the US, where you could go and find another employer, but others that say that no, we just can't have these types of clauses in the first place.
Right, and there's a kind of culture where we give our consent. It's, well, we all are familiar with the arguments. Is it real consent, or is it I have no option, so I want to participate and therefore I am forced to do it? Mm-hmm. I've seen cases like that with disclosure of emails in the workplace, etc., where you've consented that everything is... But this is still classical. There, the human rights is taking it to the European Court on Human Rights to adjudicate a dispute about potential violation of human rights, a right to court, in a different area. But more intriguing, of course, is that human rights themselves will be adjudicated in alternative dispute resolution. And I suppose the knee-jerk reaction is, whoa, isn't the whole value of human rights adjudication that it goes beyond the individual dispute and that we have a normative decision by a constitutional court, by the European Court on Human Rights, and all this goes... Because very often ADR is also private, it's not published, it's... So what do you say to the knee-jerk? Wait a minute.
So, well, as a public international lawyer who focuses on human rights, that was my first reaction. What I think has been very interesting engaging with this very vast and burgeoning literature on ADR is really trying to get to a much more nuanced point. First of all, ADR exists, it is used for human rights cases as well. We've seen, for example, Guantanamo cases that have been settled or negotiated for people coming out of Guantanamo. So it is used. Taking this knee-jerk reaction doesn't help us really understand what the value and purpose of ADR is. So in the article, what I do is really use this literature and try to engage with it to understand more of the nuances and critiques, where ADR is promoted from a justice perspective rather than an instrumental perspective, where the criticisms and the concerns are about it, particularly from the perspective of powerlessness and power imbalances. And then I take two approaches. One, I try to look at principles that already exist in international human rights law and try to use them for saying, well, how would we regulate and how would we oversee voluntary engagement with ADR? And how would we regulate and how would we oversee mandatory requirements to use ADR? And I argue that these are two very different things. So maybe to take the voluntary and give it maybe a bit of concreteness. So the argument in the ADR literature with voluntary engagement with ADR, and again then it splits into whether it's voluntary engagement that leads to a voluntary outcome where the individual has control the whole way, or voluntary engagement that leads to a binding outcome. So you voluntarily agree to arbitration or you voluntarily agree to put your case before an ombudsman that can issue binding decisions. So taking the voluntary to voluntary. So here the ADR literature will say what we have to look at is autonomy and self-determination of the person. That's important. And that's important in human rights terms as well, that we value and respect decision-making by individuals. Not everyone wants to go to court. So we start from that basis, and we know, as I said before, that the European Court does recognise that individuals can waive the right of access to a court, subject to certain provisos, like you can't waive your right to access an impartial or independent tribunal, but you can waive your access to a court provided that it's unequivocal. So in those cases, what we're trying to balance between is the autonomy and self-determination of the person on the one hand, and the other concerns raised in the literature about power imbalances, about inequality of arms. So there, what I try to draw from the European Court's jurisprudence is the ideas of equality of arms, this notion of procedural justice, where the process should be fair, effective participation. And I try to use those to balance against autonomy and self-determination, so there's a protective element. So for example, if we take a torture case, so the knee-jerk reaction is you can't possibly mediate or conciliate an allegation of torture. But of course, torture allegations are mediated and are subject to settlement negotiations. So on the one hand, we would respect the autonomy and self-determination of the person. But at the same time, we would be acknowledging that torture is, as an experience, one of the most unequal things that a person can experience. So there would be inherently a concern about power imbalances in a negotiation or mediation or conciliation about torture. So when we're looking at equality of arms and effective participation, one answer might be, well, was there legal representation involved? Another argument might be, what was the third party actually doing in the first place? Was the mediator taking a very traditional role of just trying to umpire between the parties, or were they trying to level the playing field? The other question might be, when does this mediation or conciliation or negotiation take place? So we know that Article 3 requires that there be an investigation into allegations of torture. So does it take place right after the person's released from prison, where we'll be concerned that there may be other pressures, implicit pressures, that they think they just have to agree to whatever the state offers, even if there's no obvious undue influence, any of the usual contractual reasons that we would say that a mediation agreement doesn't stand. So does it take place right then, or does it take place after a criminal investigation has taken place, where there has been a finding of responsibility? It's a very different end of the spectrum, where the power imbalances will be very different right out of prison, with no recognition that torture has taken place, to actually after there's a finding. And at that point, the person may be saying, some people will want to go to court and have a civil case on damages. Others will just want it all done. And a mediation that respects the law, or conciliation that respects the law, that's able to use the findings of the criminal investigation, may be very different at that point. Now, that's completely different from a mandatory requirement to mediate, for example, and that's what we're starting to see in some countries, including in public law cases, where there's a requirement before you access the court to consider mediation, for example. It's typically mediation. In those cases, is there a mandatory requirement to consider mediation for a case like torture? Well, the European Court doesn't help us a lot with that answer. We know that in the Ramirez-Sanchez case that it says there should be judicial proceedings when it's solitary confinement, but we don't have a case yet dealing with torture. But at the same time, the Council of Europe Convention on Violence Against Women contains a clause prohibiting mandatory use of mediation. And so if we think that the reason for that must be to do with powerlessness, but also violence, then we probably can follow that through to say a mandatory requirement to consider mediation in torture cases would not be acceptable. So that's the type of nuance.
Even in situation where it's mandatory to consider mediation, but it does not foreclose subsequent judicial proceedings if the mediation fails.
So again, this is where the literature that's not human rights literature is very useful for how we think about mediation in human rights context. So we have this case of Rosalba Alessini from the Court of Justice of the European Union, which I think is a very interesting case because it premises itself on Article 6.1 of the Convention, the European Convention on Human Rights, and it talks about, again, the right of access to court is not absolute. It can be waived. In this case, it's about online dispute resolution of consumer disputes, so very different type of dispute. And what it talks about is, well, you can be required to consider mediation when it's still in the shadow of the law and in the shadow of the courts. It's a short time period. You've only got to consider it for 30 days. There's no court fees involved. It's free. So in this situation, it's a legitimate, a proportionate response. At the same time, what you will see some of the literature on ADR saying is that's all fine and well in theory, but if you're in a situation of powerlessness, if you're in a situation where you've suffered a human rights violation, or where there's a threat that if you go to court, you're the one that's going to have to pay, in that situation, you may just agree to whatever, even though you're not mandated to agree to whatever. You may just agree because of the whole circumstances of what's going on.
Don't you find that this is a sort of little bit of a challenging question? I don't know if the label human rights activist, etc., is a fitting one, but as a human rights activist, I could imagine myself having a kind of conflict of interest, because for me, what is really important is the conduct of the state. Mm-hmm. I wanted to go to court because I want adjudication, I want to name and shame, mm-hmm. and I want to bring it to an end in other cases. But that might be in conflict with the actual interest of the victim of the abuse, who mm-hmm. really wants to get away from it, wants a fair settlement, wants mm-hmm. to forget it, wants closure, mm-hmm. and does not want the whole hassle. And it sort of might impact not how I think about it in a sort of abstract academic context, but how I think about it in a specific context, sort of egging on the person. No, don't accept mediation. It's important that it goes to court. And have you ever encountered that kind of conflict in, you direct a center, you were a practicing lawyer before? I could imagine that could come up.
Yeah, and I think that that's why the distinction between the voluntary and mandatory, again, is important. I think that of course, we're always wanting to advance the law, and that's crucially important. And one of the biggest critiques about ADR is the privatization of justice. What happens to precedent in those situations? At the same time, when we're in the voluntary and only the voluntary setting, excuse me, we do have to respect the autonomy of the person. It is their case, and I think that's always really important to think about as a human rights lawyer, provided we're really sure that the individual has the full facts of the consequences of going to litigation, the consequences of going to mediation, and they're properly supported throughout the process. So, I always think that cases belong to individuals, and I think that that is what the autonomy and self-determination respects, but at the same time you have to have the structural protections in place of equality of arms, of procedural justice, to ensure that the person is able to fully participate and make informed choices in very difficult circumstances.
Equality of arms is often compromised in those situations, because even though formally they do have legal representation, etc., it is so unequal. Mm-hmm. Mm-hmm. So if they're lucky enough to get an experienced human rights center to represent them, mm-hmm. you have equality of arms. But if it's just the local lawyer from around the corner, mm-hmm. and he or she are contending with experienced lawyers of the states who have seen a million cases, etc., mm-hmm. is there any way around that?
That's what I'm trying to get to in the article, is trying to look at this process, because at the moment when we think about, say someone agrees to a settlement, at the moment we tend to be thinking, well, was there undue influence? These very high level ways to challenge an agreement, and we're not going to capture any of this in those very high level contractual agreements. When we're trying to look at things like procedural justice, equality of arms, the lawyer not being equipped to think about this is where I think we might get closer to it. And it's not just the cases like the sharp end cases like torture, but we do see quite a lot of use of ADR is in employment cases, discrimination cases. For example, in the United Kingdom now there's a requirement to consider mediation in special educational needs cases, and when that change was happening, I've forgotten the author, but this person talked about the concern of what happens if a parent agrees to something just because they feel the pressure and they later realise that it's the wrong decision.
Talk to us a little bit about the issue of transparency. That one of the problems of ADR, that it goes below the radar, that the decisions are not published, the reasons are not published, and even if it is a satisfactory solution from sort of a high moral ground of justice, one is comfortable with it, it doesn't become part of the legal culture because it's all resolved privately. So what's your take on the transparency issue?
So in the agreement-based, it's very difficult because of the requirement with mediation for it to be confidential. There's some human rights commissions, for example, the Australian Human Rights Commission that tries to get around that, when they have to have mandatory conciliation by publishing summaries of decisions. But it's not precedent in the same way. The issue also comes up in relation to adjudicative ADR, and this is where I get to at the end of the paper, where I talk about what happens if it's mandatory requirements to use mandatory requirements to use a binding adjudicative ADR process. What if you had to go to arbitration or to an ombudsman that can produce binding decisions? And in a lot of ways, I think human rights law will struggle, and I think that's another issue in the Pakistan case about the lack of publicity of decisions. That's part of the reason people choose to go to arbitration, for example, often that there isn't a published decision, and if there is a published decision, it's not precedent. And that's one of the things that I wrestle with at the end of the paper, trying to think about, well, what is the essence of a court really? Because we see in some of the decisions, like the international organization decisions, that they talk about you can divert cases to other forms of adjudicative ADR on a mandatory basis, and you can do that provided the essence of the court's not compromised. But they tend to only talk about independence and impartiality. And what I'm trying to think about is, what is the essence of a court? I mean, we don't see that discussed a lot. Is it published decisions? So if an arbitration was required or ombudsmen were required as a mandatory process and they published their decisions, would that be enough? Or is it that they must produce precedent? Or is it that you have to be a judge? Is an arbiter or an ombudsman a different characteristic?
There's a scale there. It's better that something is published than nothing is published. It's
right.
So, are we close? Are you close in your thinking to sort of produce a code of best practice that would be out there, that would sort of give a the kind of classical functions of codes of best practice?
So there's already one by Felix Stefik, which is a general one, and a range of cases. Yeah, and I think a lot of the principles there are very useful. At the moment, I'm leading a project funded by the Nuffield Foundation in the UK that looks at the role of alternative dispute resolution with national human rights institutions. So in many ways, I've been trying to test my paper in this project. It's national human rights institutions within Europe, but we look at other jurisdictions. And one of the things we're trying to do, because we're coming to the end of that project, is to try and think about what is best practice. And again, what is best practice when it's a voluntary engagement, and what is best practice when it's mandatory. Not so much a code, but trying to look at best practice, because I do think one of the problems, and I think Nancy Welsh brings this out really nicely in one of her articles on the US, is that in a way we have all these standards that we require of the formal justice system, but in many ways we don't really have much in the informal setting, and we often rely on ethics. So mediators have ethical codes, arbitrators have a little bit more, but trying to push a bit further to see what are the best practices, but trying to use this vast literature again, which is so rich on the nuance and critique, and thinking from the voluntary outcome all the way to mandatory with binding outcome, and how the standards change that way. So this article is one that starts to think about frameworks, trying to use human rights principles to produce frameworks, and the project is trying to apply this framework and take it a bit further in specific cases.
No, in my experience, my judicial experience in quotes, is entirely in the field of arbitration. One of the, and it took me a while to understand that, but it was not just privacy of arbitration, etc., but it's the absence of other stakeholders. Mm-hmm. And sometimes, you know, it was such a big break in the WTO process when other stakeholders were allowed to produce, they don't call it this, but kind of amicus curiae mm-hmm. briefs, mm-hmm. and the procedure became more transparent, etc., etc. So that's a different dimension also, that in judicial proceedings there's more openness to involvement of other stakeholders, which is less the norm in the sort of privatization of dispute settlement. And I would imagine that for human rights that could also be pretty critical.
Yeah. I mean, as someone that has written a number of amicus curiae briefs, you often, or third-party interventions, you often wonder what the impact of these are. So it's really interesting to hear that from an arbitration perspective. And of course, that is where there's a lot of discussion on how do you bring human rights into arbitration processes and investor-state arbitrations from the perspective of the group of people or the party who's been impacted by the state company situation. So there is a lot of literature there.
There's an interesting question of how we measure the impact, because the tendency of the practicing bar is to always ask themselves, did it impact the outcome of the case? And very often the answer is probably not. But on a longer term, in terms of change of consciousness, of arbitrators hearing arguments that may not exactly come to fruition in the case before them, but they begin to think about this issue in a different way, there's a value in it that goes beyond the individual case. Why the choice of the ECHR as your benchmark?
So I thought about that a lot, and the reason I chose it was out of all the international and regional courts, it's the one that has the most jurisprudence on the right of access to a court and the right to an effective remedy. The Inter-American Court, the African Commission on Human and People's Rights, of course, also have jurisprudence, but they have mostly been presented to date with very serious human rights violation cases. So they haven't had the range that the European Court has seen, and of course they're younger and they don't have the volume of cases that the European Court has processed. So part of it was that there were principles that I could find within the European Court's jurisprudence. The other part was that I could already see that Article 6 was influencing decision-making elsewhere. So we see the Court of Justice of the European Union in the Ras Al Al-Assini case using the ECHR jurisprudence to figure out, is the mandatory requirement to consider mediation in consumer cases, does it comply or not? So we could see it starting to influence.
It was hard for me to tell whether, and maybe I'll press you on this here. So it's very useful because, as you say, there's jurisprudence, they deal with it, it's extensive, it's not only horrific cases of torture, etc. But are you altogether satisfied with the approach they take? Or is it saying, well, that's what we have, so let's at least meet that?
So, of course, the European Court's jurisprudence is always evolving, and my idea is not that other courts, national, regional, or otherwise, will necessarily always follow the European Court. I mean, you see discussions in the Inter-American Court, for example, where they suggest that they won't be following the European Court. And of course, the European Court itself doesn't always follow its own jurisprudence because of how it sees itself evolving. So the classic Ireland against the UK to Salmoni against France, where we have that in today's conditions. So I don't imagine that we're stuck with what we have.
But on the whole, do you think that the sensitivity is okay? Some
of it, in the voluntary engagement, where we can see that the procedural justice is starting to become a principle, that we can look at the process without having to only focus on the outcome. I see that as a positive way forward. When I look at the mandatory requirement to use ADR from binding outcomes, that's where I see we have the tests, but right now the way they're applying is in a very difficult way. So we have the tests in the international organization cases that I talk about in the paper, where the court says we use a legitimacy and proportionality test and the essence of the court can't be undermined. But then there's no analysis, and they just say, well, in this international organization, they say it's independent and impartial in their appeals process, so we're okay with it. So I would like to see those tests becoming much richer, and really the court explaining what does it mean by these, excuse me, what does it mean by essence of the court? Otherwise, we're only ever focusing on independence and impartiality, and we don't really get to understand, as you say, that arbitration is very different. An ombudsman is very different from a court, and where are we okay with that and where are we not okay with that?
Let's talk a tiny little bit about the field. So ADR, the oceans of writings about ADR, etc. But ADR in human rights is fairly new, at least in the sense that you are developing in your paper. In other words, not using human rights to examine other ADRs, but ADR to do human rights itself. Where is the field? Are you still a sort of lone prophet in the desert, or?
I think that there are people that work on ADR that are starting to come into human rights, and what I'm hoping with this article is really to try and open up a discussion. So I was very lucky to have a lot of people read it and engage with it as I was drafting it.
And a lot more will read it now that it's EJIL.
Of course. And we had a lot of interesting discussions along the way about, oh, well, I didn't think about this. And so I'm hoping that human rights scholars will start to think about it a bit more. I think it's really important that we, as human rights scholars and public international lawyers, think much more about what we mean by a remedy, because now this really, really matters. You know, we see the regional courts pushing back to the national level, saying, you know, we see it's getting harder on exhaustion of domestic remedies. We have to think about how these remedies get developed at the national level for human rights cases. And then we can only do that if we're really honest about what the dispute resolution landscape is now. And it not only includes courts. And so I'm hoping that this will trigger more discussion on these issues.
If you had your kind of Christmas wish list in this area, what would be the first thing you would like to find in your stocking? Or the most important thing you would like to find in your stocking?
In terms of outcomes, or? In
terms of outcomes, procedures, the most important thing that could, in your view, the biggest thing that needs to be changed, or?
Well, one of the things that actually came into the paper as a result of one of the anonymous reviewers' comments, who were so fantastic in how they helped me develop the article. And one of them asked, well, what about friendly settlements at the European Court? And so when I was thinking about, well, how does what I say apply to these? I think that would be a really interesting direction to see how can we use this really rich literature to start to think about friendly settlements in the European Court, in the Inter-American Court and Commission, in the African Commission, to build in more safeguards, more procedures there, because there my sense is it's much more instrumentalist, which the ADR literature has gone much further past now, where it's about is the state offering a settlement, yes or no, but there's not so much of the protection or about powerlessness, the idea of friendly settlements having the possibility of creative remedies, when do they happen in the process? So I think I would like to see, developments there too, connecting the literature with the friendly settlements at the international level.
Well, when we got the article, it struck me immediately this is one we have to take very seriously, because it was a little bit of a culture shock. I had myself not thought of ADR and human rights quite in the way that it was presented. It was always issues of human rights in ADR, but not ADR of human rights. And I really want to thank you. I'm sure a lot of people will read this with interest. It is opening a field, and you do it splendidly. One is left with all the right questions to ask. Thank you very much.
Well, thanks so much for the opportunity to publish it.
You're welcome.